I'd like to use this opportunity to clarify some misconceptions on the DA's position on the Expropriation Act. Let me be very clear. The protection of private property rights is the cornerstone of any economy. The DA has always championed and supported this. And that's why we fought so hard, invested so much, and expended so much energy defeating the amendment to Section 25 of the Constitution. The DA is strongly of the opinion that the Expropriation Act is unconstitutional, as was pointed out by Minister Macpherson to the President, and as I've said consistently in press conferences since, and our view has not changed. We will continue to use the GNU structures to mount our opposition to the law from within government, as was announced at the press conference on the 25th of January. As I said at that time, and in the immediate aftermath of the signing of the bill, we will approach the courts, arguing that this act is indeed procedurally and substantively unconstitutional. And that position has not changed. As long as Dean Macpherson or any other DA public representative is Minister of Public Works and Infrastructure, we will be able to mount protection from arbitrary action through the minister responsible for the Act's implementation. However, the reality is that situation cannot be guaranteed forever. It provides some short-term relief, but broader solutions are needed. Let me again be clear. Property rights are the bedrock of our economy and a fundamental right of every South African. Where there is doubt about property rights, it works against the jobs and growth agenda. The uncertainty over the many years of the debate on expropriation without compensation through the amendment of Section 25 of the Constitution, which was defeated in Parliament, thanks to largely the efforts of the DA, made it very, very clear that the uncertainty causes huge problems to attract growth and jobs and to attract investment into the country. What we don't need is another period of uncertainty and insecurity. And that's why we believe the bill, as we said at the beginning, should have gone back to Parliament so we could have fixed these problems and ensured we had a bill that was compliant with Section 25 and which ensured that we have proper redress of land ownership in South Africa through the variety of other acts that are there, but at the same time had an Expropriation Act that was compliant with both Section 25 as well as the Constitution and the Bill of Rights contained within it. That is why the DA is going to court, as we've said from the beginning, to challenge the Act on the basis I've outlined, and while we will do whatever we can to ensure that we have an expropriation bill that is in line with our Constitution and which safeguards the rights of every South African contained in Section 25 of the Constitution, which remains unamended.
DA at work, rescuing South Africa.